So, as we started, we now continue. Former President Donald Trump, federal courthouse, Washington, D.C., three-judge panel listening to arguments about the case against him for 2020 election interference and whether or not it can even go forward or he should be immune from prosecution because these were acts of his while in office, official acts. Here's what Trump's lawyers had to say when asked if Trump would be immune if he used SEAL Team 6 to assassinate a political rival.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
What the founders were concerned about was not...
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
Who's that, Bobby Kennedy Jr.? No, that's one of the attorneys making this case. Now, it is an awkward case to make, but legally, is it sufficient? One of Trump's attorneys from his first impeachment hearing is Robert Ray. We've got Bob Ray. We also have former federal prosecutor Renato Mariotti. So we heard the argument laid out. Gentlemen, both of you, Happy New Year and thank you for being here. Renato, if you don't impeach and remove, as the Constitution prescribes for a president, is he immune from anything that happened in office?
Obviously not. He's obviously not immune. And I think you don't need to be a lawyer to understand that. The judge was asking incredulously a moment ago, because on its face, it's absurd. I mean, if, for example, a president did try to assassinate his political rival and said the Senate wanted to impeach and remove him, he could just murder all the senators. And presumably, that would have no recourse, right? According to this theory of how the Constitution is supposed to work. I think on its face, it's laughable. And it's actually not in accordance with the text of the Constitution. If you look at the impeachment clause, and I'm sure Mr. Ray will do that in a moment, I think if you took all the politics out of it and had a bunch of people just look at the plain language of it, I think it's fairly clear that the framers of the Constitution did not intend for that absurd result to occur.
We'll put it up for everybody, and you and Bob Ray agree this reeks of politics, but Robert Ray sees it breaking a different way. And just what you see highlighted on the screen here before I give it to Counselor Ray, the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. The argument is, what if he's not convicted? So if he's convicted, then sure, then you can also be prosecuted once you're thrown out of office. But what if you're not convicted in the political process? Bob Ray, to you.
In other words, if you looked at the Constitution, it doesn't say, which is, I think, the argument in favor of, this is a laughable argument, which I don't think it is. The Constitution doesn't say whether convicted or not, the party remains liable and subject to criminal prosecution, indictment, trial, judgment, and punishment, which you would think, if that's what the framers intended, it would say. I have to confess, I never really thought about this when I was independent counsel trying to decide whether after Bill Clinton left office, he could be prosecuted for obstruction of justice and perjury.
You sounded more like Renato then, Bob.
Well, yeah, exactly. And I guess my takeaway is that I don't think I ever really thought about it because, I think everybody agreed that Bill Clinton's conduct, while reprehensible, didn't constitute official action in the way that we think about it now when we're talking about President Trump and other potential hypotheticals that were raised today before the three-judge panel. Also, I certainly, this was addressed at oral argument. What do you do about the case of Richard Nixon? And Richard Nixon's case was, he was obviously impeached by the House, but before there was a Senate trial and before the Senate actually took action to remove him and convict him from office, he resigned. I suspect
Well, he was
that,
pardoned.
Well, he
was
resigned
pardoned.
and
That's
then later
what
was
seals
pardoned.
the deal.
And the argument
But that
is,
seals the deal.
Well, I know, I'm not sure it does. The argument is that why would there have been a need to pardon him if he wasn't otherwise subject to prosecution thereafter? And I think the answer is the resignation probably, at least in my view, would constitute a waiver of that immunity.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find NewsNation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of NewsNation's fact-driven coverage.